Hello and welcome to Legal Briefs. Today I'm going to go over how to ace your law school essay exams. If you write a law school essay exam like you did in college, you will fail. Law school exams are completely different and I'm going to show you exactly how to ace your exams. If you're watching this, you likely are in law school, meaning you did well in college. However, you absolutely cannot write a law school exam like you did in college. Prior to law school, I really thought I would be learning different types of laws. I would have to memorize tons of law, perhaps know the variations of each law depending on the jurisdiction. And then I would be tested on my amazing ability to memorize loads of law. Well, I was wrong. Now, there will be multiple choice exams too, but the typical exam will include a fact pattern. Sometimes more than one scenario, sometimes just one fact pattern that will encompass the whole quarter or semester of what you learned. I actually had a professor who gave a cartoon, and at the end, he just wrote the word discuss. Remember, your professor has to have an objective way of assigning points to each exam question. Your exam is not going to be graded on the feeling the professor has of how she thinks you have spent time memorizing all the elements of a particular law. A law school essay exam is first graded based on your spotting of the legal issues, and then second, based on your applying the facts to the issues and facts. The first critical thing is for you to spot all issues, and we will be going through an example in a bit. Each issue hidden throughout the exam will be assigned points. You miss the issue, you miss those points. So you can write a beautiful lengthy paragraph about one small issue that may have been 5 points out of a 100-point exam and miss the deeper analysis of another issue that would have given you 20 points. You miss issues, you miss points. Simple. So spotting the issue is arguably even more important than using the facts, because if you miss the issue, you will miss all of the points, while if you at least just spot the issue, you will get at least some points. So before we dive into a sample exam, remember that your professor will not directly tell you what issues you need to discuss. The exam prompt or question will not say, please discuss if you think Mr. Bells will be guilty of negligence, or what are the elements of felony murder. All right, so you get your exam, and the first thing you do is to turn to the end of the exam and look at the prompt. Some professors will give you an indication of what they want you to focus on. For example, the professor might say at the end of the exam, you are an associate at your firm and the partner has asked you to write a legal memorandum about XYZ. Once you have that, you will then know what to look for as you're reading through the fact pattern. After you know what the professor wants, you're going to spot the issues. And we will be going over a fact pattern in a bit. So your first reading will be to pull out all legal issues presented. You outline your answers around the issues presented in the question. This should be at least a quarter of your time because you cannot miss a major issue. Now that you have an outline of the major issues, you are going to move to the second part, which is fact spotting. You need to make sure that every fact given to you is used. Every fact in the essay is there for a reason. If it is not there to help your case, it may be there to give you a possible argument for the other side. But as you are reading through, every issue leads you to facts to discuss what will rack up those points. Now you have an outline of the issues, and under the issue, the facts that apply to each issue. This is your outline for your response. Your issue and fact spotting should take up about 25 to 30% of your time, leaving approximately 70 to 75% for actually writing your answer. Okay, so let's take a look at this exam. This was an actual torts exam. This exam had several parts, and this part was worth 60 points. So the first thing you do is need to go to the end and read the prompt. Here it says, you have been assigned to prepare an assessment of Bell's legal prospects. What does this mean? This means you will be focusing on this person Bell's injuries. So let's look at the fact pattern. Okay, so here we are introduced to Bells, who lives on a property next to a property owned by Delbert. Then Delbert hires Lee to clear the property, but Lee was not able to do so because of the tall weeds on the property. So Delbert then contacts Omi to clear the property with the use of a brush hog. So right away, these facts give rise to the issue of vicarious liability. Was Omi an employee of Delbert, or was he an independent contractor? Did Delbert have power to supervise or control the manner of which Omi conducted his business? Then the fact pattern continues by describing what a brush hog is. It is basically a large machine designed to help clear the property powered by a tractor. So what is the issue here? Is a brush hog an abnormally dangerous activity as to give rise to strict liability? The fact pattern continues with Omi beginning the work, and as Bells is walking in his own backyard, he is struck in the face by a piece of wire that was thrown over 80 feet from the land by Omi's brush hog machine. The facts state that Bells was in his own backyard. So here there's a nuisance argument, as well as possible negligence use. The fact pattern continues to say that Bells suffers loss of an eye and other serious and permanent injuries. He wants to sue, and now you are tasked with preparing an assessment of his legal prospects. So the issues here, we can see damages, but they're not really in dispute, so maybe not even meriting a discussion. There are a few more added facts. We know that Omi is not insured and has very limited assets. What's the issues here? These issues give you an indicator that Omi will not be the main focus because practically speaking, getting a judgment from a person with limited assets would be a waste of time. But that doesn't mean he is not liable, so you still need to discuss liability on his part, but just not in great length. Next, we have the additional facts of Omi warning Delbert when he was standing too close to the brush hog machine. This gives rise to the issue of whether a reasonable person would act in the same or similar circumstances. So as we're reading the fact pattern, I basically outlined what I would be discussing, and my outline would basically look like this. So the Bells versus Omi section is probably about 10 points. 5 points maybe for issue spotting, and then the professor may give 5 points simply for pointing out all the relevant facts in the analysis. This should be an easy 10 points. The Bells versus Delbert issues are obviously where most of the points are. If you spot all 4 issues, you probably get about 25 points here, and if you're able to work in the facts in a coherent discussion, you are well on your way to getting most of the points and a good grade. Okay, so recap. Once you have the issues and the corresponding facts, you write down the relevant law and discuss the facts. That's it. This is not the time to discuss policy and the evolution of how the law came to present day. Just spot the issues, lay out the rule, tie in the relevant facts, and done. Done and out. Please let me know if this was helpful and let me know what other tips you would like to learn. Good luck.